right. All right, everyone. We're still have participants coming in, but we're going to get started since it's 3:05 and we have a lot to cover. So thank you, everyone, for joining us today. My name is Max Bookman, joined by my father and partner, Robert Bookman, as well as Joni Yoswein and Jeffrey Denman of Yoswein, New York. This is being hosted by the New York City Hospitality Alliance. For those who are on this call and don't know, the Hospitality Alliance has become the essential industry trade association in New York City, representing thousands of bars, restaurants, hotels, and nightlife establishments throughout the city for 5 or 6 years now. But it's become an indispensable organization during the pandemic. The Alliance has been at the negotiating table, on the front lines, advocating for every single pandemic-related measure that has assisted our industry in the past year, and many more that we've been fighting for. So we thank, we're proud to be founding members of the Alliance, and we're appreciative that the Alliance has put together this important program today. My father and I are partners at Pesetsky and Bookman, which is, we are a specialist in alcoholic beverage law regulation. We are legislative and general counsel to the Alliance, but we also represent a wide array of bars and restaurants, distributors, manufacturers of alcohol, and a number of regulatory related issues regarding alcoholic beverage regulation. So we bring a certain amount of expertise to the table that we hope to explain a little bit more about today. And Joni Yoswein is the founder and CEO of Yoswein, New York, which is one of the top public affairs firms in New York State. She and her team have skillfully represented the Hospitality Alliance from the beginning in Albany. The Alliance is extremely grateful for her important work. And Jeffrey Denman is a vice president at Yoswein, who has been part of our team as well and will be joining us on today's call. So you'll hear from all of us today. With that, I will turn it over to Robert for a substantive introduction of some of the topics that we're going to cover today.
Thank you, Max, and welcome everyone to this interesting, we hope, important seminar. We anticipate that we will answer many of your questions by the end of this program. And we will also, you will see that there are many questions that cannot be answered yet because we have a new law. It's 135 pages, which is a hefty law. And believe it or not, it does not answer every question. But like any new law going into a new area like this, there will be a rollout period, which we will get into in detail. There will be lots of regulations that are going to be adopted based on the legislation. There will more than likely be changes in the law by the time the law goes into effect or shortly thereafter, based on issues that people didn't contemplate when they passed the law or unintended consequences. There will be a lot of that. But we got here because for years, state by state, there has been advocacy to legalize marijuana. New York has been on a path to doing that, and we are here now. Where we are is, so that's how we got here. Where we are is a bit confusing because some portions of the law went into effect immediately. Some will take some time. We are going to focus this, seminar on the licensing aspect of the law and what that means for entrepreneurs who want to get into or think they may want to get into the business. That you will see that there will be a lot of parallels to alcohol beverage regulation. There is a tiered system, for example. It's a state regulation with a specific license categories, very similar to what those who are in the food and beverage or hospitality industry are used to. But there will be major differences as well that we will touch on. There are things that doesn't exist in other areas of the law. It doesn't exist in the alcohol beverage control law. For example, businesses who want to get into this area are going to have a what's called a labor peace agreement with a union that wants to unionize your workers, saying that if they come to you, you're prepared to allow them to so unionize. That's very, very different from what anybody's used to. There's also significant social and economic equity targets in the law, including community contribution plans that everybody who's applying for a license is going to have to lay out and comply with, because come renewal every 2 years, you're going to have to show that you actually did everything that's in your community contribution plan. So we're going to talk about that, and the Yoswein team, that's especially part of the area that they discuss, because a lot of that's going to relate around community relations and creating a good relationship with those in the neighborhood that you want to apply for a license for. We're going to talk about projections and how long it's going to take. Right now, nothing much is going to be happening as far as license applications in the next 6 months, because that's how long it's going to take to set up the state agencies, set up the process that they're going to for license applications. And it may even be longer than that, but it won't be less than 6 months before the first application will be available. So this is probably one of 2 minimum seminars that we will be doing, concerning the licensing process. And like I said, there will be many questions that will remain open. We are going to ask that you use the Q&A function, and we will reserve a good portion at the end of this hour and a half for answering your questions. Hold off on it because on putting them on typing them in, because we do anticipate that we will get to many of the questions, just knowing naturally what they're going to be. So without any further ado, let's get into the substance of all of this, and I will turn it back to Max.
Great, thank you, Rob. Yes, we're over a year into the pandemic, so at this point, everyone should know how to use the Q&A function. But if you're new to this format, it's right at the bottom of your screen where you have several options. One of them is Q&A. Feel free to type in your question. We'll try to get to them all, although we expect a lot. And therefore, as Rob said, try to hold off initially on your questions to see what we could touch on. The other thing I want to, Rob, are you going to say something?
Yeah, if we don't get to your questions, you could just email Pesetsky and Bookman. We will respond. We anticipate that our firm is going to be very active in this area as far as pursuing applications on all the various tiers. So feel free to email us after this if we don't get to your question today.
That's right. And the other thing I just want to underscore is, we're going to talk about what we know and talk about what we don't know, but we have a wide array of people participating on this call who come from different industry sectors. We have real estate agents. We have people in the real estate sector. We have, I'm sure we have attorneys and others who are paying attention. For those who don't know, when a new law is passed, creating a new regulatory regime, the law does not answer every specific factual scenario that there is. The agency that is created is given leeway to create regulations and rules that fill in a great amount of detail. And so once we have those additional details, we'll cover a lot today, but once we have additional details on some of the vague areas, which I'll be pointing out and identifying, several months from now, we'll do a follow-up webinar where we could discuss anything new that we've learned from the regulations that have been passed. And one thing that Rob didn't mention, but we should also expect is, just like any brand new law, this law will be changed. It'll be amended, likely, in all likelihood, it'll probably be changed before, any of the licensing elements, come into effect as the agency that's created actually starts to try to implement the law. And then without a doubt, within the first few years, if not sooner, of its operation, once we are living with the law, there may be minor amendments made to it as well to either correct things that were ambiguous or make changes that are needed. So I'm going to cover 5 topics with the time that I have. What is it that's being regulated by the new law? Who will be doing the regulation? What are the different license categories, which we've received many questions in advance of this about what type of license categories will there be? So we're going to spend some amount of time on that. What is the application process going to look like from the information that we have now available to us in the statute? And lastly, what is the social and economic equity component of this law? It's been much publicized. There's been a great deal of writing on it, but we're going to get into the details of what the social and economic equity piece really means when it comes to getting a marijuana license. And then after that, we'll take your questions. So what is being regulated? The entire marijuana supply chain is being regulated by this law. And it is the lens through which the legislature approached this question in terms of what is being regulated is by looking at the supply chain. And every industry has supply chains, every product has supply chains. What is going to make marijuana special, and this is similar to alcoholic beverages for anyone in the liquor space, is that the supply chain for marijuana is going to be specifically enshrined in law and segmented and get different treatment depending on where in the supply chain you are. So the law identifies 4 steps in the supply chain: cultivation, processing, distribution, and retail. And there's going to be license categories that cover each of those steps in the supply chain. And we're going to cover each of those. But from a broad perspective, if you intend to go into business, or if you represent someone who intends to go into business, or if you are on this call because you're curious about going into business in the marijuana space in New York, now that it's been legalized, if you're going to be involved in any of these activities, you are going to need a license in order to do so. And these activities, these 4 categories, cultivation, processing, distribution, and retail, they are designed to encompass the entire scope of the supply chain from seed to sale and everything in between. So if you're going to be involved in all in this business, you're going to need a license. So who's doing the regulating? The law creates something called the Cannabis Control Board. And that is a high-level board that's going to be in the top decision makers in the regulatory sphere. So the Cannabis Control Board is going to be composed of 5 members. One of those members is a chairperson. They will each have an equal vote. And they will have a number of high-level powers when it comes to the regulation of marijuana in New York. So they'll have final say on approving or disapproving license applications. They'll have final say on whether active licenses should be suspended, canceled, or revoked for violations. They will be the board that promulgates rules, issues advisories, issues guidance, issues declaratory rulings. They will, which provide further guidance on how they interpret the marijuana law. The board will have the power to limit or not to limit the number of licenses that are issued in the state of New York and the categories of licenses that exist. They'll have the power to set production limits on an individual license basis. So then, if you are in the cultivation or the processing tier, and we'll talk about what those mean. They may set license limits on what your license category allows. They may also set overall production limits on what the industry as a whole may produce in a given year. They're also going to set the health, safety, labeling, package, and advertising standards of marijuana produced in New York State. And this is different when you compare it to the alcohol industry, where really those activities, health, safety, labeling, packaging, and advertising, are really done at the federal level by and large in the alcohol space. But we don't have at this time a federal marijuana regulatory agency. And so those types of activities, setting THC content standards, how the THC concentration is disclosed, packaging to make sure that the products are not attractive to minors, the types of disclosures on the packaging are all going to be done at the state level and done by this board. one other important function of this board is that they're also going to have the final say on the social and economic equity plan, which we're going to talk about. They're going to be responsible for implementing that plan, and the law requires this board to do a 2-year review after the first retail sales in New York start being made. 2 years later, they're required by law to do a 2-year review to take stock of how the industry has developed in its first 2 years and potentially modify existing licenses to further the social and economic equity goals of the industry. So for those familiar in the alcohol space, the Cannabis Control Board is similar to the full board of the State Liquor Authority. They are the top level decision makers. Under the Cannabis Control Board is the Office of Cannabis Management. That is the actual administrative agency that's going to be doing the day-to-day regulation of the industry. They will be the ones who accept license applications, that process licenses, that create the paperwork requirements, deal with the day-to-day work. So they answer to the Cannabis Control Board. They are controlled by the Cannabis Control Board, but the Office of Cannabis Management, and this is the only acronym that I'm going to use today. Usually with government stuff, you wind up getting a lot of acronyms. I try to avoid that, but the Office of Cannabis Management is a mouthful, so I think people will be calling it the OCM. I think they already are. So the OCM is answerable to the Cannabis Control Board. There will be an executive director of the OCM who will head the agency. And importantly, there will also be, and this is defined in the statute, a chief equity officer. And the OCM's chief equity officer will be the primary point person for developing the social and economic equity plan, which will govern how the board handles social and economic equity applicants.
So again, for those of you familiar with alcohol regulation, like we are, with the exception of the equity officer, this is a structure that we're somewhat familiar with. You have a board, you have the State Liquor Authority, you have somebody in charge of that agency. So that so far it's familiar.
And for anyone who's on this call who has already tried their own hand at reading the statute, you may see that there is language that says that the OCM is located within the Division of Alcoholic Beverage Control. Do not be misled by that. Prior versions of this legislation, going back to 2019, actually did have the State Liquor Authority playing an important role in regulating marijuana. And that's what a lot of other states have as well. But the final version of this bill, which went into law, has this separate Cannabis Control Board. The Office of Cannabis Management is, we think, located within the Division of Alcoholic Beverage Control just for back of house, essentially state back of house purposes. But for all intents and purposes, the State Liquor Authority is not going to have any thing to do with cannabis regulation in New York. It's going to be the Cannabis Control Board and the OCM. There's one other organ here, administrative organ, just to make a very brief mention of before I move on, which is something called the Cannabis Advisory Board. So the statute does create a 13-member advisory board, which is going to be created. It's going to have diverse representation across the entire geography of New York State, as well as across industry. So different industry representatives, regulators, different appointees from within and outside of government. And they have some statutory power to make recommendations to the Cannabis Control Board, especially as this regulatory regime is getting on its feet. They also have power to make recommendations on the social and economic equity plan. So there is this advisory board that's created, which, we'll see. There are other advisory boards in industry. The Alliance has members that sit on advisory boards. Rob sits on the Health Department Advisory Board. Andrew Ridgey, our Executive Director of the Alliance, sits on the Nightlife Advisory Board. So we'll see. It's important to have these boards because they do provide some outside perspective. So that's the overall structure. That's who is doing the regulating. Let's move now into the license categories, because this is something that I know many of you have questions on. Many of you have expressed to me questions before this webinar, and I've said watch the webinar because you'll get your answers. So here are some of the answers. as I said, the regulatory approach here is to look at the supply chain. So the types of licenses that you see on your screen closely track the segments of the supply chain that the law has created. So there are 5 main license categories. And I'm going to talk a little bit about each. And I suspect this may generate several questions. Before I say anything about any license category, just to reiterate once more, this is a law that paints license categories in broad strokes. The statute does have something to say about what you can and cannot do with each license category, and anything that the statute has to say, I'm going to talk about. But there is a lot that's going to be left to the OCM, to the Cannabis Control Board, in terms of filling in the details of what your day-to-day operations will look like in each of these license categories. So the first two types of categories are in what in the alcohol space we would call the manufacturing tier, the people who actually make the product. And that's a cultivator's license and a processor's license. There is a similar distinction in the alcohol regulatory space, but in cannabis, the law really makes it explicit. So a cultivator license will allow you to grow, clone, harvest, dye, cure, grade, trim cannabis plants. So a cultivator license is for someone who really wants to be in the farming business of growing the marijuana plants for use as cannabis. Look at that in contrast to a processor's license. What the processor's license allows you to do is take already grown marijuana plant and do things to it. So blends, extracts, infusions, concentrates, anyone who is going to be creating edibles, tinctures, anything where you're taking the plant and you are producing it into something else, you will need a processor license in order to do. Now, you can have a cultivator license and also be a processor. So in other words, if you want to do both of those things, if the business that you're interested in getting involved in is both growing the plant and processing it, then you will be allowed to have a cultivator license and a processor license at the same licensed premises. But before we get into the other license categories, one thing that's important to note, and Rob touched on this, is that there is a tiered system. And in the alcohol space, that's called a 3-tier system. And what that means is not only is the supply chain being separated into different license categories, but generally speaking, you're not going to be allowed to participate in multiple segments of the supply chain. And the way that works out in reality is you're not going to be able to have multiple licenses in multiple tiers. I'm going to get into a little more of that in a little more detail as we move on. But as a general principle, what you need to understand if you're considering getting into this space, this is just like alcohol, you're going to have to decide which segment of the supply chain, which segment of the industry you want to be in. If you want to be a manufacturer, you can have a cultivator license. You could also have a processor license, but you're not going to be able to also have a dispensary license or an on-site consumption license, which we'll talk about. So you can't be in the retail tier and the manufacturing tier at the same time. This is taken directly from the alcohol industry. It has a 80, almost 90-year lineage, but the purpose of it is to combat vertical integration in the industry, which is just a fancy way of saying to combat you having full control over the product from seed to sale. There are some exceptions, which we'll talk about, but by and large, you have to pick what segment you want to be in.
And to be clear, when we say you, we mean you in any form that you might organize yourself in. So it's not just ABC Corporation can't be a cultivator and a dispensary. It's all the individuals behind ABC Corporation in whatever format. So if you're a part owner of a cultivator license, just like in the liquor law, you're a part owner of a winery, you cannot also be a part owner of a restaurant, or a bar. And in this case, you will not be able to be a part owner of an on-site consumption license or dispensary license.
All right.
Want to be clear.
And so I'm going to talk a little more in a minute about what licenses you can and cannot have with other licenses. But just to finish going through the different categories. Next down is what's called a distributor license. And this is also something that if you're experienced at all in the alcohol space, this will be a very familiar license category to you. This is essentially the wholesale license, the wholesaler. So a distributor will be a business that purchases cannabis either in its plant form, or from directly from a cultivator or from a processor, and they will sell it at wholesale prices to the last tier, which is the retail tier. Distributors it appears from the law that they're going to be regulated similarly to the way alcohol distributors are going to be regulated. For example, there's going to be restrictions on the types of interactions that they could have with retailers and the type of financial arrangements that they can get into with retailers. We'll talk about that in more detail if we have time. The board, the Cannabis Control Board, can set maximum prices and have price controls for distributors, set the amount that they can mark up their prices. It's not clear exactly from the law whether there's going to be a price posting system the way there is with alcohol. So if you're in the alcohol space, you may know that if you want to purchase a particular bottle of wine from France from a particular distributor, there's a public price posting where it's a level playing field where any retailer could purchase at the same price from. It's not exactly clear from the law whether distributors will be able to do that. Also, credit terms. I mean, that's something that is a carryover from the alcohol law. So, and it's actually more severe. So distributors in the alcohol space, they can offer product on credit. So if you're a restaurant, you could purchase alcohol on credit as long as you pay back in a certain term, which is clear under the law. There is no credit sales under the marijuana law. So distributors can only sell for cash on delivery, on COD, although they can accept credit cards. So that's the distributor's license. Also, if you are a cultivator and or processor and you also want to distribute your own product, you will be allowed to do that. You can get a distributor's license as a cultivator or a processor, which will allow you to distribute your own product. You just won't be able to distribute other people's product if you are a cultivator or processor. Then let's get into two of the last two categories, which we're going to focus the most on this webinar, because we suspect that in New York City, and this is an event sponsored by the Hospitality Alliance, the New York City Hospitality Alliance, we'll probably see the highest concentration of these two license categories in New York City. And that's the dispensary license and the on-site consumption license. So both of these licenses are in the retail tier. So these are retail, to consumer-facing license categories, which means that, again, because it's a tiered system, you're not going to be producing the product. You're not going to be distributing the product. You are purchasing the product from New York State licensed distributors, processors, and or cultivators. The dispensary license, for those who come from the alcohol world, they'll be familiar with the term off-premises. This is an off-premises license category. This means that you will be selling marijuana products to consumers who will then take it home with them or take it elsewhere, take it off of your premises to use off the premises. This is for anyone who is already in this space or has observed the legal marijuana space elsewhere in the country. This is the category that you're probably most familiar with, because this was for dispensaries, the classic dispensary where you sell product from. Dispensaries will only be able to purchase from New York State licensed cultivators, processors, or distributors. So no importing from other states, no importing from other countries. And again, that is a function of the fact that of marijuana's status on a federal level. We'll talk more about what dispensaries can and cannot do, but that's the dispensary category. And the last and really most interesting, I think, license category is the on-site consumption license, because not every other state has something like this. Actually, most states that have legalized marijuana do not have something like this. This is a license category that will allow for, again, borrowing a term from the alcohol space, allow for the on-premises consumption of marijuana, both smoking and consuming. Although there there are some interesting questions about how New York City's smoking laws, indoor smoking laws, interface with smoking marijuana, which Rob may touch on if we have time after I'm done talking. But so this is a separate license category, which really the only real analog is, the classic Amsterdam style coffee houses where you could smoke or ingest marijuana on the site. There is a license category for that. A lot has been left unmentioned in the statute in terms of how these on-site consumption businesses will operate. There is some stuff we do know. For example, you're not going to be allowed to have gambling, which should not come as a surprise. You're not going to be able to have alcoholic beverages on these on-site consumption facilities, which is a real disappointment. This is something that the Alliance had lobbied for, to allow businesses that hold liquor licenses to also be eligible, on-premises liquor licenses to also be eligible for these on-site consumption licenses on the same premises. But so that you could have, go ahead, Rob.
Right, at a minimum, we were trying to push to allow New York's famed restaurant chefs and bartenders to create drinks and foods and desserts, with THC and with marijuana. That has not happened in this version of the law.
Which is a disappointment. So as it currently stands, if you're going to have an on-site consumption license, you could have a liquor license somewhere else. There's nothing against you as a person investing in both businesses that sell alcoholic beverages and also another business that sells marijuana for on-site consumption, but you can't have them both happening at the same premises. Some other restrictions that we do know about, you're going to have to be 21 years or older to enter one of these facilities, an on-site consumption business. Your employees are also going to have to be 21 years or older if they're going to have a consumer-facing facility or if they're going to interact with marijuana product at all. But as I said, there's a lot that's still left unknown. So really, there's no discussion in terms of if there's any preferred method of operation of these businesses and sort of, how, what a traditional on-site consumption business is supposed to look like. No discussion of any food requirements, either, sort of non-infused food, which is something very different from the alcohol space where every business has some sort of food requirement. No discussion of bathroom requirements, hours of operation, indoor or outdoor components or preferences. None of this is currently in the law, and that we expect will be the subject of regulation.
Right. A lot of that's going to have to get fleshed out in regulations. The consumption of other items other than marijuana on the on-site consumption license lounges is particularly interesting, and how that interacts with New York City and other local laws concerning that. We know an on-site consumption license is not allowed to have any alcohol on the premises, so we know there won't be any of that. But will you be allowed to have a variety of other foods, non-marijuana foods, non-marijuana drinks, juices, sodas, whatever? Is it going to be a requirement or even? We don't know. The law is pretty quiet about all of that. And of course, there's an interesting question, which we will not get into, but I'll just quickly mention it now, and that in New York City, while this law is pretty clear that localities cannot prohibit smoking of marijuana on on-site consumption lounge licensed premises, New York City does not allow indoor tobacco lounges, tobacco stores where you could smoke tobacco, do not allow them to have any other food or beverage. So we don't know how that's going to play out here, and it's something that will have to play out. It's hard to imagine the state contemplated having a lounge that you can't also have a soda or a drink of water. But that is one of the questions that remain unanswered that will have to be dealt with in the next half a year or so.
Yeah. The on-site consumption lounges will allow for the sales of marijuana on-site. So this is not just because I've already seen some comments saying that these on-site won't work economically unless you could also sell the product. So on-site consumption lounges, you will be able, and that's how it's going to work economically, is you will be able to sell marijuana, but it's going to be for on-site consumption, for people to consume it on the site. It's not clear also in the law whether marijuana that is sold to your customers for on-site consumption can then, if it's not finished, can it then be taken home with them? So is this, for example, can the only thing that you sell at an on-site location be, pre-rolled joints or edibles that could only be consumed there? Or can you take it home with you afterwards? So we'll have to see as well how the regulations are, play out with that.
But it's clearly not intended as a dispensary. So there's going to have to clearly be some regulations concerning unused marijuana. Half a joint is not consumed, half the brownie is not consumed. There's going to have to be some regulations concerning the packaging of that and how somebody could take that with them, while keeping the intent of the law that you are not a dispensary. You're not there just to sell stuff to go.
I would also speculate that there'll probably be, limits on the amount of marijuana that you could sell at an on-site lounge, so that there is something different about the dispensaries. The dispensaries, probably could sell higher quantities, but that's just my speculation.
That's mine too. But basically, dispensary is a liquor store and an on-site consumption is a bar, right, in the marijuana field. Yeah.
A few other comments about these license categories before moving on to the other topics. Just moving to the point of my notes. So there are going to be license limitations. So cultivators and processors and distributors, only one license per person. So what that means is you as an individual can only invest in one business that cultivates marijuana. Only one business that processes it and one business that distributes it. And if you're invested in a business that does all three, cultivates, process, and distributes, then that's your three. In other words, you can't invest in other businesses that if you're invested in one business that does all three, you can't invest in a separate business that distributes. In addition, there are with that said, by the way, there is a provision in the law that allows for a cultivator to have multiple locations under one license, which is something unusual from the alcohol laws. But if you have a cultivator license and you have multiple cultivating facilities, you can have all of those facilities all under one license. But the point is, as an individual, you can't be invested in two different cultivation businesses.
Still, right. The distinction, right. There may be multiple locations for the business that you are a partner in or an investor in, but you cannot be an investor in multiple people's businesses.
Right. Moving into the retail tier, there is a rule of three. So you can, if you are invested in a dispensary, I should say it this way, you can invest in a maximum of 3 dispensaries in New York State. You could also invest in a maximum of 3 on-site consumption licenses in New York State. But, and this is a critical distinction, you cannot invest in on-site consumption licenses if you're also invested in a dispensary, and vice versa. You can't invest in dispensaries if you're also invested in an on-site consumption license. So that is a big limitation, and is going to limit and really require you to pick within the retail tier which segment of the retail tier you want to be involved in. Because if you want to be involved in a dispensary, you could have a maximum of 3, but then you can't have an on-site consumption license. And the opposite is true as well. If you want to be involved in the on-site consumption business, you can do that, but then you can't be involved in dispensaries. And that really is different from alcohol. Alcohol has a limit on the number of liquor stores you can own, but there's no limit on the number of bars or restaurants you can own. And if you want to have a bar or restaurant, you could also have a liquor store. They did not copy that word for word when it came to the cannabis law, and they made it much more strict. So that's something that's really important to know at the outset.
And again, that is to meet an intent in the law, public policy in the law, to keep the industry as diffuse as possible. With one noted exception, the 10 companies that have been licensed in New York State for medical marijuana, who tend to be large companies, they did get some sweetheart part of the law, which is allowing them to get into multiple tiers. Nobody else will be able to.
So before I move on to into the next step, which is the application process, again, for anyone who's actually been reading the law or trying to read summaries of it, you may see something called a co-op license or a micro business license come up. These are small production capped license categories that will allow some relaxation in this strict tiered system that I've talked about. So the co-op, if you have a co-op license or a micro business license, you will be allowed to do some of each of these activities: cultivate, process, distribute, dispense, and potentially sell on site, all under one license category. But there are restrictions. To be a co-op, there are rules about what it takes to be a co-op, and the micro business category is going to be severely capped in what can be produced, and has really been left vague and left for the agencies to decide, the agency OCM to decide what is a micro business. So I'm not really going to spend much more time on that. I'm going to move now to the application process.
And before we do that, I'm just, I'm going through a lot of questions, seeing what the questions, and a lot relate to this issue of ownership, which I guess we haven't made clear. Passive, there's no difference in the law, just as there's no difference in the alcohol law between being a passive investor or an active investor as far as the number of licenses that you can be a part of. If you are a human being, no matter how your investment is, no matter how de minimis it might be, no matter how passive you are, everything we said as far as the limitations on the number of licenses and the limitation in the categories applies. Doesn't matter if you're a passive investor or an active participant in the business as it relates to those issues of ownership and how many and the tiers.
So if you're here representing a VC fund, for example, and and you represent the investments of, or a private equity fund, this is not, this webinar is not, is going to raise questions. It's not going to be conclusive, but, for you're going to have a lot more diligence to do, but you should understand that this law is designed to prevent that type of investment distributed across the industry. It's really been designed, and part of what was essential to its passage is to ensure that ownership of businesses in the marijuana supply chain are really kept local and are not concentrated. And so, as Rob said, there's no distinction between active or passive investment. If you're investing at all, if you're owning at all, you're subject to these limitations.
We also need to look further. One of the questions that's not 100% sure, if you already are an investor in such a business in another state that where it's legal, whether you will be allowed to be, an investor here in New York as well, or is that your one? That is still not 100% sure.
So let's move down to the application process, because we've also received a lot of questions before this webinar in advance about, when could I apply and what's that going to look like? So we're going to talk a little bit about that now. So for this piece of the legislation, understand that the legislature was really not writing on a blank slate. They borrowed heavily from the alcohol licensing application process. And so for anyone who's familiar with that field, you're going to see a lot of similar concepts and criteria, although with some significant modifications for cannabis. So for anyone who's applying in the retail tier, so that's the dispensary license or the on-site consumption license, and you're in the city of New York, your application process is going to start with a 30-day notice to the local community board. It's called a 30-day notice because you're not going to be able to file any applications with OCM until at least 30 days has passed after you've notified the community board.
I don't know. I just think I heard a collective groan from all 267 people on this.
Well, I think I heard it too, and you may have heard it from my office when I first read this bill, because anyone who's familiar with community boards knows that they require a special touch, and in the case of marijuana, it's going to require a real special touch, and this is something that Joni is going to touch on shortly. They will play an important role in the process, and so anyone who's familiar with community boards should expect to have expect their usual processes for alcohol licensing to be similar, if not more robust, for marijuana licensing. That notice is not required for the other categories. It's just for the retail categories. After that, after the 30-day notice period is over, or if you're not in the retail category directly, you will file your license application with OCM. People who've asked, how soon can I get a license? How soon can I apply? It's this part of the presentation, which is the answer as to why you can't file right now. a brand new state agency has been created. They have to, the executive director has to be hired. The board needs to be constituted and appointed and confirmed by the Senate. Staff needs to be hired. Physical office space needs to be rented. The law requires them to have offices in New York, Buffalo, and Albany. Application forms need to be created, processes created, and then those forms need to be made public. They need to hire people to process those forms. All of that is going to take months. So that's why you cannot today file a license application. With that said, we know from the law that some of the things that they're going to be required to, that you're going to be required to disclose, and that is similar to alcohol licensing. So you're going to have to disclose your entire ownership structure. So if there are investors, if it's not just two people or one person or whatever applying, and you have multiple investors, you're going to have to disclose who all those investors are, and you're going to have to show where you're getting your money coming from. There's also in the application process going to be some physical criteria, which are stated in the law. If you're for dispensaries, certainly the law says that you have to be located in a storefront at street level. That's for a dispensary. It's a little vague. That requirement of being in a storefront and at street level might also apply to the on-site category. We're going to need some clarification on that because the law is a little vague. Other physical criteria, there's going to be a 200-foot law prohibiting any licensed retail license category within 200 feet of a house of worship. There's also going to be a requirement that any retail license category has to be 500 feet from any school grounds. So that's more than in alcohol. In alcohol, it's 200 feet from houses of worship or schools. It's 500 feet from school grounds with under the cannabis law. So those things will be evaluated as well.
And don't forget, school grounds is different than the alcohol law, where it's door to door. It's measured to the school door, not even the edge of the building. Here it's ground, so 500 feet to a playground, to the edge of a playground. So that's going to knock out a lot of areas, where one would be eligible to apply for a space.
Right. In addition to the physical criteria, there are applicant selection criteria that the law sets out, and there will be more that the OCM and the board promulgate through rules. In terms of selection criteria, I like to think of these as hard criteria and soft criteria. Hard criteria being what we call in the alcohol space statutory disqualifications, meaning criteria that the board cannot waive, that are sort of very clear right now whether you would be eligible or not. Those criteria are copied by and large from the alcohol space. So with some minor tweaks, so just to run through them quickly, you cannot own, invest, be a passive investor, partner, have anything to do with a business that has any type of marijuana license if you are a police officer or law enforcement officer, if you are under the age of 21, if you have committed a felony in the past 5 years involving fraud, money laundering, forgery, or unlawful conduct related to owning a business. So that's actually better than an alcohol license, which is basically any felony category. This is a specific set of felony categories. If you had a previous marijuana license revoked in New York State, which nobody has now, but as the years go by, that's going to happen. So if you have a previous marijuana license revoked, that's it for you. You can't invest in any other business that has it. Also, if you've committed a misdemeanor or felony violation of the cannabis law in the past year, so if you've been involved in unlawful, selling of marijuana since this law went into effect, you're disqualified if it happened in the past year. And there's a U.S. citizenship or lawful permanent resident requirement as well, although there's some vague language that makes it unclear how that's going to play out with large LLCs with multiple investors. It seems from the way the law is written that it's at least possible that you can have up to half of your investors not be U.S. citizens, but we're going to need some clarification of that as well. So that's the hard criteria. There's also going to be soft criteria. And when I say soft criteria, what I mean from that is criteria where it's not exactly clear whether all of the things I'm about to say must apply to you, or if only, or instead, if they're just a sort of a mix of things that the board is required to look at in any sort of combination and give any weight to. So, for example, and there's several, and I'll run through them. Whether the applicant is a social or economic equity applicant, that's a criteria that the board is required to consider. But obviously, not everybody is going to be a social or economic equity applicant. You're going to have to demonstrate that you have a legitimate plan to make sure that your product is not being sold to underground markets. You're going to have to demonstrate that you have a legitimate plan to show how your business is going to benefit communities and people who've been disproportionately impacted by the marijuana prohibition. You're going to have to show that you're of good moral character, that you have a labor peace agreement. And this is something that Rob touched on, which, as he said, is an agreement that if your workers do want to unionize, that you're not going to stop them from doing so. You have to demonstrate how that you're going to have one of those, or commit that you'll have one of those. Your energy and environmental impact, you're going to have to submit a plan, especially if you're in the cultivation and processing tiers, showing how your electric use and your water use is not going to impact negatively the nearby environment. You're also going to have to show, and this is the last soft factor I'll touch on, how your application is in the public interest, which is a term that has been imported from the alcohol laws and is, and we'll see if it winds up having the exact same meaning. But the statute does say that the board needs to consider things like the number in determining whether your application is in the public interest, showing the number of other licenses in the area, the impact on noise that your business will have, the impact on pedestrian traffic, history of violations at the premises. So these are all what I call soft factors that in some combination and in some weight will be looked at as well. You're also going to be required to keep your word. And what I mean by that is these licenses are for a 2-year period, just like liquor licenses. You're going to have to renew them every 2 years. And one thing that's right there in the statute is you're going to have to show how your labor peace agreement is still in place after 2 years and that you've not violated it. Your plan that you said that you would have, showing how your business is going to benefit the communities that have been traditionally disadvantaged by the marijuana prohibition, you're going to have to show how you executed that plan. So those are very progressive requirements that are not present in the alcohol laws that you're going to need to really be mindful of, not just when you're applying, but throughout the life of your business. I'm mindful of the time here, and so I'm going to move just quickly to the last piece of what I wanted to say, which I know there's been a lot of questions about before I turn it over to Joni and Jeff. And that is the social and economic equity element of the statute. And sort of what does that mean? Because as I've said, there's been a lot of discussion in the press about that. And from a political element, it's been this piece that we've been told really is what helped get the law over the finish line when it couldn't in 2019. And so what does that mean? Social, economic, and equity. Social and economic equity. So as I said, there is going to be a chief equity officer who is going to be hired. The first thing that chief equity officer is going to be responsible for doing is developing, with the help of the Cannabis Advisory Board and with the Cannabis Control Board, a social and economic equity plan. There's going to be public input on that plan. And what that plan is going to do is it's going to be proposed, it's going to be then adopted by the board, and then its implementation is going to be designed to promote the social and economic equity goals of the law, to help individuals who have been traditionally left out of the cannabis, legalized cannabis in other states, people who have identities that are consistent with having been traditionally disadvantaged by the marijuana prohibitions, to encourage them to get into this space. So although the actual nuts and bolts of the plan are not developed yet, because that's what the chief equity officer is going to do, the end goal of that plan has been made clear in statute. So what that plan is supposed to be designed to do is to ensure that there are at least 50% of all licenses issued under this statute be issued to social and economic equity applicants. So it's a target. The goal, the goal of the plan is to target 50% of all licenses issued across all categories to be issued to social and economic equity applicants. Now, what does it mean to be a social and economic equity applicant? There are 4 ways to be a social and economic equity applicant. And I'm going to tick them off, and then I'm going to get into some details on 2 of them. Either a minority-owned business, a woman-owned business, a distressed farmer, as defined in the New York State Ag and Markets Law, or a service-disabled veteran. So to be a minority-owned business under the cannabis law and thus be eligible as a social and economic equity applicant, at least 51% of the business or more must be owned by minority group members with real power over the day-to-day decision-making and operation of the business. Minority group members are also defined in the law as Black, Hispanic, Native American, Asian or Pacific Islander. Asian includes the Indian subcontinent. If you meet those categories, then you are an individual who is a minority member under the law. If you're a minority member, then you count towards the 51% or more that the business must be in order to be eligible for social and economic equity applicant treatment. Women-owned business is the same analysis. 51% of the business or more must be owned by women with power, again, power to exercise over the real day-to-day operations of the business. So passive investors who meet this criteria are not good enough. You're going to have to demonstrate to the board that those who meet these criteria are actually exercising real day-to-day control over the operations of the business. And somebody just asked this, and so I'll just reiterate. Yes, the Indian subcontinent. Actually, I read the question quickly. Does it include the Middle East? I'm not so sure. It says Asia. So that'll be up for the board, I guess, to decide in regulation. And they're going to have to decide a lot more in regulation. In addition to everything I've just said, the social and economic equity plan is also going to be required by statute to have provisions that give extra priority, beyond the priority I've just described, extra priority towards people who meet the following 3 criteria. They're a member of a community that's disproportionately been impacted by the marijuana prohibition. They have income that's less than 80% of the mean area income. And they've been convicted of a marijuana-related offense before the law went into effect, or they had a parent or child or spouse who was convicted by a marijuana-related offense. So just sort of to summarize what we know about social and economic equity applicants, number 1, this is a major goal of the legislation, is to ensure that people who meet the criteria I've described get their foot in the door and get to have licenses. Number 2, there's going to be a plan that shows how that's going to be implemented on a more detailed level, which has not been developed yet. And number 3, the goal of that plan is so that 50% at least of the licenses that are issued under the law go to applicants that meet these criteria. So with that, I will, unless Rob has something else to say, we'll turn it over to Joni.
Quickly, one other area we wanted to quickly cover, and then we'll turn it over to Joni and Jeff to talk more about, what all this might mean, from a community relations perspective. And that is, you've probably read a lot about local governments throughout the state, counties, cities, towns have the right to opt out of all or part of this law. They have until the end of the year, the end of this calendar year, to do so. So theoretically, the city of New York could opt out of, they can't opt out of the legalization of marijuana, but they can opt out of the dispensaries, they can opt out of growing, they can opt out of the on-site marijuana lounges or combination thereof. So as we sit here right now, we don't even know exactly where in the state of New York people are going to be able to apply for these licenses, because towns and counties are first getting organized to talk about it. We suspect that it'll be more liberal because you only have until the end of the year to opt out, and then you can always opt back in. So we suspect that the opposite. We suspect that a lot of places might choose to opt out just to opt back in later on. But if they don't opt out by the end of this year, then they have no opportunity to opt out. So we don't suspect that New York City is going to opt out, given that our state legislators were at the forefront of getting this law passed. But that does not mean that there cannot be additional local time, place, and manner is what the law says, restrictions on where these lounges and dispensaries could be located. While the law says 500 feet from school property, the city might choose to pass a rule or a law that says, and no more than 500 feet from each other, like they did with adult entertainment zoning, where in addition to being X number of hundreds of feet away from a residential district, from a school, from a religious institution, it was also 500 feet from another adult entertainment establishment. We might see something like that here, so there's not a concentration of locations within a particular neighborhood. We don't know yet, what any of these local restrictions are going to look like, and that's going to come, again, as the months go by. Go ahead, Max.
All right, let's turn it over to Joni and Jeff.
Yeah.
Okay. Thank you very much. So I just want to take 2 minutes and just talk about why this year, 2021, are we talking about social justice as part of the legalization bill. Legalization bills have been introduced in the legislature since 2013. They've always been talked about and generated in terms of economics for the state of New York. How are we going to create a new way to create some financial base for government? And the legalization of was really one of those ways. What's happened now is a confluence of a number of issues. So we have other states leading the way. We have medical marijuana in New York. We have a legislature that's made up of younger members and more younger members. So it's not just more members, but they're younger as well. And you have supermajorities in both houses. So what has happened is, and I'm not minimizing the governor's juice or anything like that, but there is more leverage now in the legislature. But what has really happened is that the dynamic about creating a funding source has really been trumped by the social justice import of a legislative agenda, that this bill is one of many bills that are going to adjust and address injustices that that people in the city and state of New York have received. So that's kind of how we got to this place. There are two consequences, big consequences, I think, related to this. One is we're going to see more elected officials at all levels of government more engaged. For good, for bad, they will be more engaged. There will be so much more at stake. They will be at their community board meetings. They are going to want to know who is interested in the different licenses. They will become very important players, more so than just their responsibility, and I'm not minimizing that, as state assembly members or state senators. The second consequence is really engagement. And Jeff, I'm gonna pass over to Jeff in a couple minutes. But the whole idea of engagement with communities, it's similar to land use projects in the city. How firms like mine have viewed land use projects. You're going to take valuable property. And property is valuable financially, but it's valuable because there's a limited amount of property certainly in the city and state of New York. And you're going to make an investment. And you really, if you want to do this right, you want to do it with input of the community, because then you're going to get a project that there's buy-in, that people feel invested in. And that's going to happen more and more when it comes to this issue. So when it came to a land use project as a model, let's say IKEA IKEA was, we represented IKEA, Swedish furniture store, 350,000 square foot furniture store in Red Hook on the waterfront, was perceived as a big box store, totally remote community where even DMV was having a driving test there because there were just so few cars on the road or people on the streets. What did you do? The first thing we needed to do was build relationships with people that would be most affected. Those happened to be people that lived in Red Hook houses. And we had to listen to find out what were the needs. We were going to not promise jobs, we were promising an opportunity. But how do you build a relationship so there's going to be trust? So there you can create that opportunity and you really can create jobs and livelihoods and a new future for people that want it. And that kind of relationship goes two ways. IKEA itself, what people were interested in particularly in the community most affected, health benefits for part-time workers. What benefits would there be for people that had been previously incarcerated? We could address those issues. We listened to what the questions were, and it helped get a better project. And it certainly brought great accolades from the community board members because it brought an excitement about creating these new opportunities. So those relationships, it's not just about spending money. It's not just about investing in a ticket here or a ticket there. It's really going to be about meeting people and listening to them and what their fears are and how you address those fears and get past them. So there's a sense of trust and there's a sense of, you know what, we might not be able to do this, but this is what we want to do. How do we get there? And those communications is essential. And the model of many of these land use projects, I think, is going to become mini models for many investors in different parts of this, of our whole new opportunity that we're going to have. I'm going to hand it over to Jeff, Vice President of our firm, deals with community engagement on many, many issues, as well as the lead on our Alliance state legislative issues. Jeff?
Thank you, Joni. Thank you, and good afternoon, everyone. As Joni mentioned, my name is Jeff Denman, Vice President here at Yoswein, New York. So as Max kind of mentioned earlier, there are a ton of parallels between the liquor licensing process and what we foresee to eventually become the cannabis licensing process. So what we thought would be a good exercise is to kind of walk you through the importance of community boards, the importance of outreach to community boards in terms of the success of your processing, what we expect to be similar, and what we expect to be a little bit different here. So as I mentioned, community boards are super important to the liquor licensing process here. And while they're very important, many community boards use different processes, different applications, different required outreach prior to coming to the board. But nevertheless, it's always super important that you do your outreach and your homework on a community board in the community prior to coming to them. These things are super, super, super important here. So outreach to local block associations, outreach to tenant organizations, outreach to community groups and other stakeholders can really determine if you're successful or not successful here. We've all seen the applicant that's shown up to the community board or read about the applicant that showed up to the community board and didn't learn anything about the community, didn't do any pre-outreach, didn't solicit any forms of collateral that show community support. And the more often than not, it's shooting yourself in the foot and almost guaranteeing that you're not going to have a successful outcome. On the other hand, we've seen applicants that get in early, introduce themselves to the community, seek support from community members, do outreach to local stakeholders, and thus are able to demonstrate collateral either through letters of support, folks actually showing up for them, and petitions that show that the community is in support of them. And more often than not, that'll have a profound impact on if you're successful or not throughout the process. So given that we've covered kind of the importance of community boards and the importance of outreach, what I'd like to kind of move on to is what do we think is going to be similar here? And what do we think will likely be the same? So community boards the respective community boards that you're applying to, and ultimately the Cannabis Control Board, will want to see some demonstrable level of community engagement, as I previously mentioned. This not just shows that you have a level of respect for the community to get there early and really talk to them about them and really kind of ingrain yourself into the community in a meaningful way. It's also a way for them to show that the community is in fact supportive. So contact with adjacent neighbors, support letters and petitions, like I mentioned, support letters from business in the neighborhood. And one of the things that we really thought are going to be important here that are going to be even more important in the cannabis process is the role of block associations and tenant groups, particularly just because the cannabis legislation passing isn't necessarily going to change some folks' sentiments on marijuana. So we think that's going to be a super important part of the process, and thus getting in there early and having a compelling narrative and a compelling story is going to be very important. Additionally, business improvement districts have proven to be very, very, very impactful in terms of moving community boards and garnering their support for particular applications. So having covered what we expect to be similar with both the liquor process and the cannabis process, let's get into a little bit of the meat of what we think is likely to be different. And as Max has touched on, and as Joni has also touched on, the thing that makes New York State's cannabis law really different and many folks' view very superior is its commitment to social and economic equity, particularly for folks that have been hurt the most by cannabis prohibition. So as you might have heard, 40% of the revenue generated by marijuana taxation is going to be redirected directly back into the communities that were most impacted by marijuana laws through grants, social justice agencies, and even community groups that are looking to operate programs. Hence, our strong inclination here is that you really use this prism as a guideline to both formulate your community outreach plans, but also just really as your compelling messaging component as you're talking to folks. So we're not asking you necessarily to parachute into a community and decide what's important to them and what matters to them and what resonates to them. Hence, the timing becomes very important here. So our advice to you here is that you get in early, you identify local leaders and community groups, but also local social justice and nonprofit organizations, not just in terms of showing them respect, but also to glean information on what resonates with those communities and what's going to be important to them. We really think it's a great idea not to think of your community contribution plans as, you know, a list that you check off as you move through the community, but something that really drives your meaningful engagement with folks. Now, as Joni touched on a little earlier, one of the things that we think is going to be very different here is our elected official engagement. As many of you may know, elected officials have traditionally opted to kind of sit out the liquor licensing process, just given how important it was to the legislature to make sure that there's a social justice component to this bill and that the wrongs of marijuana prohibition are genuinely righted. We anticipate that you're going to see a lot more elected official engagement. And again, similar to your community groups, your tenant leaders, your bids, and things of that nature, getting in early with compelling messaging and really showing them the respect of coming out early and walking them through what your plans is, not just from an operation standpoint, but from a standpoint of what's really going to be your community contribution is going to be super important. So making sure that legislators are aware of not just your operational interests, but really how you plan on contributing to the community. And naturally, for folks that are in different parts of the supply chain, that's just naturally going to look differently for you. So very difficult at this juncture to really tell you what exactly is going to resonate and what isn't. That's going to be different depending on different boards and different communities. So in conclusion, I'm sure the question you're asking yourself right now is, Jeff, that's all great, but we still have regs coming. It's April of 2021. What can I do now? And our advice in the simplest terms is start getting ready. There's a lot of things that you can do right now that are going to be very impactful down the line. They're going to kind of go snowball into a successful outcome for you. So it's a lot of the things that I've already mentioned, which is begin that groundwork now. Even if you're not ready to specifically talk about the details of your operations, business, or community agreements, at least start getting out there and learning who the stakeholders are. Maybe even start introducing yourself to them. Really figure out who are the social justice organizations in the communities that you're getting into. What are the business improvement districts? And obviously, without any real regulations, we're not expecting many of you to have identified, street addresses. But if you at least know a community that you're looking to operate in, you can kind of start doing a lot of that groundwork of identifying groups. We would also encourage you to start attending your local community board meetings. Just really start figuring out what are the internal dynamics, how are their SLA board, how are their SLA committees performing, what are some of the leadership dynamics, what are some of the issues that are of importance to them, and really start kind of being able to figure out how your messaging can kind of fit into that, and how hopefully even your application as a whole can begin to fit into that. And then finally, I just kind of want to sum up my remarks and kind of, making sure that you're very intentional about how you're able to communicate your interests to the community and your community commitments, and not just your operations. We really believe that applicants that have strong, compelling narratives around their application and can effectively and early enough communicate that to communities and really get them on board, in addition to producing those pieces of collateral that I mentioned, are going to be a lot more successful than even folks that may even have more compelling applications, but just haven't done that homework. So with that said, thanks a bunch for listening, and thank you.
That's great, Jeff and Joni. That's exactly what people needed to hear. Actually, to everybody on this webinar, the basic answer to Jeff's question is, what can I do now? Is you've already started that answer by signing up and listening to this last hour and 15 minutes. That's a great first step, what you've taken. And I hope that what you've taken away from this is that this is a complicated area of law. It's not just going to be like, slapping together an application for a bar or a restaurant or a microbrewery. While it may be too early to file an application for a particular location, because as Max said, there is no application, yet, it's not too early to start thinking about the ideas Jeff and Joni discussed. To start putting your team together, because even if you have the truth of the matter is a lot of what we discussed is going to be applicable no matter where you decide to apply, regardless of what the restrictions might be. A particular location you have in mind may not work out, once local restrictions, kick in, but neighborhoods might. And in general, the process we now know, the general process. So it's not too early to start thinking about, who your ownership team is going to be, and getting a team together of professionals who will work with you early to get your application and to get the concepts of your application and what these plans are going to look like, to reach out to the unions, et cetera, which are going to be required here, because we think that those who file good applications early are going to be in the best shape here in this industry, especially if there are restrictions, which we anticipate there might be in New York City, about density of these businesses and how close they might be to each other or in a particular neighborhood. So, we're pretty confident that we're not going to see the number of licenses that we have for alcohol. There are over 13,000 establishments just in the city of New York where you could sit down and have a drink now. We have more on-premises licenses in the city of New York than any other state in the country, with the exception of California. Colorado, that's been doing this for 9 years, has only 1,000 licenses, current in the entire state after 9 years of application. So we're not going to be seeing thousands of these, lounges and thousands of these, of these dispensaries, more likely hundreds. And so those who get in early and get in right, meaning a good, thorough, complete, accurate application that meets all of the goals and gets approved early, are the ones who are going to get into the business first.
Yeah.
While I know Max and I have been trying to answer a lot of questions online, while we were, while Joni and Jeff were talking, so a lot of your questions were answered. One question that I wanted to save, because a lot of people have asked it, is I have a bar, I have a restaurant right now. It has an outdoor area. We're allowed to smoke right now under the current law in a portion of that outdoor area. Am I going to allow people to smoke marijuana in that portion of outdoor area where smoking is allowed? Or am I going to have to police what people are smoking in the smoking allowed outdoor area? And unfortunately, the answer is you're going to have to police what people are smoking in the allowed outdoor area. If that outdoor area is part of your liquor license premises, meaning it's part of the plan that you submitted to the liquor authority, where people are allowed to consume alcohol, it's part of your premises. Even those limited areas where smoking is allowed in those outdoor areas, roofs, backyards, 25% of those spaces, you will not be allowed to have alcohol. The flip side question was asked, well, what about, I got a pizza place that has outdoor area. We don't have an alcohol license. Will we be allowed to have marijuana consumed and smoked in those outdoor areas? That's a more interesting question. I know Max and I, we've been talking about this. In many ways, the answer seems to be yes. If you're allowed to smoke in 25% of your outdoor space, which you are now in New York City, as long as it doesn't have a cover and it's open to the sky, will people be allowed to smoke marijuana there? And the answer seems to be yes, but on the other hand, that assumes a BYOP, a bring your own pot, being allowed. And in New York, BYOB is not allowed. Bring your own bottle is not allowed, other than for places that have a liquor license. So are they going to allow, bring your own pot in places that don't have a pot consumption license? Remains to be seen. You agree, Max?
Yeah, I want to just tick off a few quick answers to questions that have been coming in. If Brittany, because we're reaching the hour and a half mark. If Brittany, but we started a little late, so we'll go a little later. If Brittany or Savannah, if you could put in the chat our contact information, mine, Rob, Joni's, and Jeff's. I know a lot of people have been asking how they can get in touch with all of us to talk offline, and we're going to have to talk offline about many of the questions because we're not going to be able to get to them all. But just to run through a few, and I think some people may have come late. Or you haven't listened to the whole time, which is okay. When can we start submitting applications? Not now. We got to wait for the OCM, the Office of Cannabis Management, to be formed, to be staffed up, to create applications. So we're still several months away, but that doesn't mean you shouldn't start, as Jeff said, thinking about how you're going to address the important questions to get your application approved right now. Marissa Simpkin, who I know well, is on here and asked a question that I would expect her to ask, which is what do you think the certificate of occupancy is going to have to say? I assume use group 6. Great question, Marissa. No idea. That's a detail that is going to have to be worked out by the OCM. That's not it's an important question, but not covered in the statute. Paul Sears, board member of the Alliance and longtime client of ours, who was just mentioned in the Journal News the other day for his distillery upstate that he just opened or is opening. He wants to know, and other people want to know as well, is there any sort of similar, just like there's farm category licenses, like farm distilleries, is there a farm producer's license where you could have all elements of the supply chain under one roof? Doesn't appear to be so. So I don't believe so. Others have asked about sort of, one-day events. Are there any?
Get to the one-day event. Having said that, that's the kind of thing that we think that will probably get addressed later on, because they want to encourage, in this case, it's not a matter of encourage. Everything's going to have to be grown here in New York. There is, though, and a lot of people ask that. No, you cannot import product from outside of the state. That's true for any of the states where it's legalized, because it's unlawful, federally. So they can encourage these local farms. They might allow, we think, a consumption or dispensary associated with a farm grower, but we just don't know yet.
Yeah. People have asked about, one-day permits. In the alcohol space, you can get something called a one-day permit. Yes, there are provisions in the law for one-day permits, marketing events, which have really been left to the discretion of OCM to come up with the details on. But there will be marketing and one-day permit type of permits that you can get on a event by event basis. Lots of questions about community boards and municipalities and how their input compares to the, what that means in relation to the opt-out provisions. So let's just be clear, two separate things. One is that by the end of this year, every municipality in the state of New York will have the option, if it wants to opt out of the law, either in whole or in certain parts. And that has to be done through popular referendum. We suspect many will. I don't think the city of New York will, but there are some suburban places that very well may.
Does not have to be by popular referendum. It could, the opt-out is by the legislature, the local legislature. It could be overruled by popular referendum.
Okay, good, thank you. So that's like an on-off switch. If the municipality, we're talking about New York City because it's the New York City Hospitality Alliance. But if you're thinking about opening somewhere outside of New York City, if you're in a municipality that has opted out, well then none of these licenses that we've discussed are open to you. But if you're in a location that has not opted out, you still need to, if you want a retail tier license, you still need to send a 30-day notice to that municipality. And in New York City, that's the local community board prior to having a retail tier license. And that community board or municipality may still express an opinion to the OCM against your particular license. If there's something with your particular location or your concept or your failure to do outreach or your failure to have a legitimate plan in place to address the social and economic targets of the law that they oppose your application on, and that will be reviewed. That opinion will be reviewed by OCM. The law requires OCM to put in writing how the opinion of the community board and municipality factored into the ultimate decision it makes.
But in addition to that, and as I read a lot of the questions, the question is, to what extent are there limitations other than recommendations on a particular application? To what extent can there be local limitations? And the law does allow municipalities, in addition to opting out of a particular category, again, they can't opt out of marijuana possession being legal. That's a state law. There's no opting out of that. But they can opt out of any of the categories or all of the categories that we went over in the beginning. And again, if they opt out, it's out, subject to, popular referendum could overrule the local town board or the city council. But in addition to that, the law does allow for the municipality to have additional rules, what they call time, place, and manner restrictions. And it's not defined what time, place, and manner restrictions are, but we anticipate it could be things like marijuana dispensaries have to close by a certain hour. Marijuana lounges have to close by a certain hour in our municipality. I think that's for sure municipalities are going to be allowed to do that. Will it be community board by community board control of hours? I doubt it. Can they have further zoning limitations? Yes, no question about it. They may decide that certain areas, and that could answer the C of O question, that a dispensary can only be located in a certain zone. And as long as that is not overly restrictive to the intent of the law, then it will be okay. Although it could wind up in litigation. Otherwise, if a municipality says, the only place it could be zoned is, 2 places in our entire municipality, well, that may be overly restrictive. So there are a number of levels of restrictions. There are going to be the state restrictions. There's going to be municipal opt-in or opt-out restrictions. There's going to be municipal time, place, and manner restrictions when they do opt-in. And then there's going to be individual community type of input, like what we see with which will be recommended, which could very well be followed, like the Liquor Authority often follows a community board recommendation.
Yeah. So I'm going to answer just a few more questions because we started 5 minutes late. So we'll just go a few more. Several questions about the racial and ethnicity reporting requirements. How is that determined? How is it determined is still up to, it will be up to OCM to decide, but you will have to disclose in your license application if you want to qualify under the social and economic equity program, you have to disclose how you qualify. Questions about What, some people looks like they've tried reading the law themselves. What is a registered organization? So Jacqueline Green has asked, what is, and others I've seen as well, question about the registered organization adult use license. A registered organization is one of the existing medical marijuana companies that has existed in New York under the 2014 law. They're the ones who have gotten a sort of special carve out from this tiered system that will allow them to basically do seed to sale. So anyone who's not one of those organizations is not a registered organization, and you could just ignore that language when you read the law, and you're subject to the various restrictions on the supply chain that we've talked about. Others have asked variations of the following question. I want to, I have a bakery or something, and I want to basically produce edibles, and I want to sell them at my bakery or where my premises. And under the law as drafted, you can't do both. You cannot, if you're making edibles, you're essentially what they would call a processor, or potentially even a cultivator and processor. If you're growing the marijuana and putting it into the edibles, you're both. But if you're getting the marijuana from other legal channels and you're just making the edibles, you're a processor. A processor can only sell to distributors. Processors can't sell directly to consumers. Only retailers, either on site or the dispensaries, can sell to consumers. So this is what we are talking about when we're talking about dividing up the supply chain and not allowing vertical integration of the supply chain. You can't do, you can't do, that business model, is not legal under the law as currently written. I think, we're probably at the extent of people's attention spans at this point. Rob, was there any last questions that you were dying to answer? You're on mute. You're on mute. You're on mute. You're on mute. Rob, you're on mute.
I've only heard that 1,000 times. Right? I know we got a lot into the weeds on a lot of stuff here, no pun intended, or actually pun intended. I guess we try to answer a lot of the questions. It looks like we answered, at least half of the written ones. And I think a lot of the other ones that we didn't specifically ask, we have answered in our conversation, but all of our contact information has been posted. This is the beginning. It's not the end. Again, both of our firms are going to be active, in getting licenses to people. It's an exciting new area. It's something that we're very happy that it's happened. The social equity stuff is interesting, and it's New York, and it's not Massachusetts, and it's not Colorado. It is New York, and we think that makes it, while more complicated, more interesting. And we're here for you. The Alliance is here for you. This will be an ongoing process, and just want to thank all of you for joining us. I hope it was instructive to you and helpful. And please send us some feedback, because we would like to know whether you enjoyed it or not.
Yes, our contact information is in the chat, and you could easily Google both of our firms online. So with that, we're going to end the webinar. Thank you very much, everybody, and take care.
Thank you.